Today we're looking at 20 questions on property condition disclosure. Here we go. What is the primary purpose of property condition disclosure laws? A, to protect the interest of the real estate agent. B, to ensure buyers are fully informed about the property's condition. C, to guarantee the property value. D, to determine the sale price of the property. To ensure buyers are fully informed about the property's condition. Property condition disclosure laws are designed to inform buyers of any known material defects, allowing them to make an informed purchase decision. Which of the following must a seller disclose in a property condition report? A, the neighborhood crime rate. B, known material defects in the property. C, the previous owner's financial history. D, the selling price of nearby homes. B, known material defects in the property. Sellers are required to disclose known material defects that could affect the property's value or desirability, such as issues with the foundation or roof. A seller is aware of significant foundation crack in their home but does not disclose it on the property condition disclosure form. This is an example of A, full disclosure, B, a latent defect, C, fraudulent misrepresentation, D, standard practice. C, fraudulent misrepresentation. Failing to disclose known issues like a significant foundation crack is fraudulent misrepresentation, as the seller is concealing information that could affect the buyer's decision. In most states, who is responsible for completing the property condition disclosure form? A, the buyer. B, the real estate agent. C, the seller. D, the home inspector. C, the seller. The seller is typically responsible for completing the property condition disclosure form, as they have first-hand knowledge of the property's condition. Which of the following conditions is often required by law to be disclosed, even if not visible during a walkthrough? A, the paint color of each room. B, previous repairs or renovations. C, presence of known environmental hazards like lead-based paint. D, the seller's reasons for selling. C, presence of known environmental hazards like lead-based paint. Many states require the disclosure of environmental hazards such as lead-based paint, asbestos, or mold, as they compose health risk to buyers. Before we move on, please subscribe, like, and comment. It really helps us out. Thanks. What is the potential consequence for a seller who fails to disclose a known defect on the property condition report? A, the sale price of the property is automatically reduced. B, the agent takes responsibility for the oversight. C, the buyer may sue the seller for damages. D, the seller must pay for a new property appraisal. C, the buyer may sue the seller for damages. If a seller fails to disclose a known defect, the buyer may take legal action against the seller for damages or may rescind the sale contract in some cases. Which of the following is considered a latent defect? A, a large crack in the driveway. B, faulty wiring hidden inside walls. C, peeling paint on the exterior. D, a broken window. B. Faulty wiring hidden inside walls. A latent defect is a hidden defect not easily discoverable by inspection. Faulty wiring inside walls would be classified as a latent defect. In some states, sellers must disclose psychological stigmas associated with the property. Which of the following is an example? A. A fire on the property. B. The previous owner defaulting on the mortgage. C. A previous owner's death on the property. D. A plumbing issue. C. A previous owner's death on the property. Psychological stigmas, like a previous death on the property, may need to be disclosed in some states as they can affect buyer perceptions even though they do not physically affect the property. A buyer asks the agent if the basement floods. The agent knows it floods, but the seller did not disclose it. What should the agent do? A. Refer to the buyer to the property disclosure form. B. Withhold the information to protect the seller. C. Inform the buyer about the flooding issue. D. Ask the buyer to speak directly with the seller. C. Inform the buyer about the flooding issue. Agents have a duty to disclose known material facts about a property even if the seller omitted it from the disclosure form. Failing to do so could be considered misrepresentation. If a property was found to have a defect after the sale, but the seller had completed the disclosure form to the best of their knowledge, the seller is A. Liable for repairs, B. Not liable if they genuinely had no knowledge of the defect, C. Required to offer a partial refund, D. Obligated to pay the buyer's inspection cost. B. Not liable if they genuinely had no knowledge of the defect. Explanation. If the seller completed the disclosure honestly and was genuinely unaware of a defect, they are typically not held liable for issues discovered after the sale. When completing a property condition disclosure, sellers should A. Only disclose issues that are easily visible, B. Report all known material defects, C. Ignore minor cosmetic issues, D. Only disclose recent repairs. Report all known material defects. Sellers are required to disclose all known material defects, not just visible or recent issues, to provide an honest picture of the property's condition. Who is responsible for verifying the accuracy of the property condition disclosure form? A. The buyer, B. The real estate agent, C. The seller, D. The home inspector. C. The seller. The seller is responsible for the accuracy of the information provided on the property condition disclosure form, as they have the most knowledge of the property. Which of the following would most likely need to be disclosed by the seller on a property disclosure form? A. New landscaping in the backyard. B. A leaking roof that was repaired but still shows water damage. C. The distance to the nearest school. D. Plans for future development. B. A leaking roof that was repaired but still shows water damage. Even if a defect like a leaking roof was repaired, signs of water damage or past issues with the roof should be disclosed as they could indicate a history of problems. If a property is being sold as is, what does this mean in relation to disclosures? A, the seller is not required to disclose any defects. B, the buyer accepts the property with no inspections allowed. C, the seller must still disclose all known material defects. D, the property does not need a disclosure form. Before we move on, please subscribe, like, comment. Appreciate it. Thank you very much. C, the seller must disclose all known material defects. Selling a property as is means the seller will not make repairs, but they are still obligated to disclose all known material defects. If a buyer finds an undisclosed defect after purchasing the home, they may have grounds to A, cancel the real estate agent's commission, B, request the previous owner's financial records, C, sue the seller if the defect was known and not disclosed, D, increase the mortgage amount. C, sue the seller if the defect was known and not disclosed. If the sellers knew about a defect but failed to disclose it, the buyer may have grounds to legal action to recover damages or seek other remedies. What must the seller disclose about lead-based paint in properties built before 1978? A, the seller must provide a lead-based paint disclosure. B, the seller must remove all lead-based paint before sale. C, the seller must pay for the lead inspection. D, no disclosure is needed if no children live in the property. A, the seller must provide a lead-based paint disclosure. Federal law requires that sellers of homes built before 1978 provide buyers with a lead-based paint disclosure and any known information about lead hazards. If a seller intentionally omits information about a known defect, this is called A, innocent misrepresentation, B, fraudulent misrepresentation, C, implied warranty, D, a material exemption. B, fraudulent misrepresentation. Intentionally failing to disclose a known defect is fraudulent misrepresentation, as it is a deliberate attempt to mislead the buyer. Which of the following is typically not required on a property disclosure form? A, information about recent roof repairs. B, details about flooding history. C, information about local crime rates. D, presence of hazardous materials like asbestos. C, information about local crime rates. Local crime rates are not generally required on property disclosure forms, as they relate more to the neighborhood than to the property itself. When should a seller provide the property condition disclosure form to a prospective buyer? A, after closing. B, at the time of the offer. C, as early as possible, typically before or at the time of the offer. D, only if the buyer requests it. C, as early as possible, typically before or at the time of the offer. Sellers are expected to provide the property disclosure form early in the process, often before or at the time of offer, to give buyers a full understanding of the property's condition. In a state where property condition disclosures are legally required, if a seller chooses not to provide one, they risk A, reducing the asking price, B, being in violation of state law, which could lead to penalties, C, having the buyer assume all responsibility for defects, D, delaying the closing process. B, being in violation of state law, which could lead to penalties. In states where property condition disclosures are required, failing to provide one can result in legal penalties as it violates state law. Well, I hope you did well. We want to encourage you to visit our channel. We have hundreds of real estate exam questions that'll help you pass your real estate exam. Once again, please subscribe, hit that notification button so you don't miss one of our videos. Like and comment below. Thanks. Have a great day.